Love it. Okay. I know we still have some people joining us, but I know we also have a lot of content to cover in just an hour in which to do it. So, hi everyone. Welcome to our 2024 Labor Law Update. Today sponsored by the Central Valley Regional HR Hotline. My name is Anna Manzano Fairbairn, and I am the Digital Media and Event Strategist here at the California Employers Association. Before we officially kick off today's presentation, I have just a couple details to go over with you. As you see, your audio is muted throughout today's training, but there will be lots of opportunities to engage during the session. If you have any questions pertaining to the presentation, you can type them into the Q&A box at any time, and we'll try to address them as we go. We have one of our additional trainers, Mary Bradford, here, who will be helping manage the Q&A box while our trainer Astrid, who you'll meet in a second, will be delivering the content. Handouts for this training were sent out in yesterday's reminder email. I know we did have a few last minute signups, and sometimes they go to the spam folder. So if you need them resent, I'm more than happy to do so. If you put your email into the chat box, I'll get that done in the next few minutes. Last but not least, we have a survey. I promise it's only 5 questions, less than 2 minutes, but the feedback that you provide really does help us at CEA. We share the results with our friends at Central Valley Hotline, and we collectively use that information to make sure that we are continuing to develop these trainings and these entire suite of resources to in turn serve you. So if you can take the 2 minutes to provide us with the feedback at the end of today's training, there will be a QR code, and I'll also drop a link in the chat, and we would greatly appreciate that. All right, now that the housekeeping is out of the way, I have the great privilege of introducing our trainer today. So today we have Astrid Servin, one of our HR directors, who will be delivering the content. And as I mentioned, we have Mary Bradford, another amazing HR director, who will be helping us in the Q&A. And I know we have a lot to cover this hour, so Astrid, it's all yours.
Thank you so much, Anna, and welcome everyone. Thank you for spending your lunch hour with me today. We're going to talk all things new laws for 2024. But before we do that, as Anna said, we want to just thank the Central Valley counties that you're seeing here for their support in providing this HR hotline that's complimentary to you all. So I see some familiar names. I know we've talked to some of you in the past when you call in. Remember, this is a free, no-cost HR hotline to you. If you're in one of these counties, please look at your hotline number and use that to call us. Any guidance you need for HR support, everything from the beginning employment cycle when you're hiring people all the way to the end where you're terminating employees, we have you covered with guidance towards that. So you get a free 15-minute call with one of our HR advisors, including Mary or myself. We take turns answering those calls. You can also email us as well. So we're looking forward to helping you and providing additional support through the hotline. But what we are not is a law firm. We want to make sure that you all know this presentation should not be relied upon as legal advice. We do have a lot of laws to cover, best practices, and we're going to tell you about the laws, but this is in no way meant to be legal advice for you. If you have some sort of question or something of legal significance, we want you to discuss that with your attorney so that that conversation can be privileged and confidential, and you can get guidance on that. A lot of times we can help get you to the point where you speak to your attorney, so definitely utilize us. We are an HR firm, so if you find that the hotline is not sufficient, you need a little additional HR support for your company, then consider membership through us. So you go to employers.org and you'll find various different membership plans that you can join us for. We are, like I said, a HR consulting company. We have, in addition to the hotline, we offer lots of forms, policies, handbooks, templates, fact sheets, guidelines, and we also do trainings such as this. We do them on site, we do webinars, harassment training, all kinds of trainings for compliance, and also soft skill training. So if you need guidance and support, again, in HR, consider some membership. You can visit us at employers.org. So what we'll cover today, and it's going to be rather quick because we have quite a bit of information to cover with you. We'll start off with the paid sick leave expansion that we have, and that's new to California, the additional expansion there of sick leave. How does that impact you? We'll talk about the new bereavement leave for new reproductive loss that needs to be added to your bereavement leave. We're going to talk about cannabis. We've been talking about cannabis for some time in California when the law passed last year. Well, now it's in effect, so we'll talk about what that means for you. And we'll discuss the workplace violence prevention plan, which is a new requirement that you'll have to satisfy in the summer. So we'll talk about those requirements. Then we'll discuss wage and hour, minimum wage and exempt salary, because we're in California and it seems to be over the last few few years that we continue to get increases. So what is it now and what does that mean? Agency and regulatory changes will also be discussed. And at any time, go ahead and find the Q&A box at the bottom of your screen there, and that's how you can ask us some questions. Maybe there's something you need clarification about when I'm talking about these leaves. And as Anna said, Mary Bradford is in the background there answering your questions. I appreciate Mary's assistance in answering your questions. So with every labor law update, we tend to have a takeaway. What's the big takeaway for 2024? And the big takeaway is you have to update your employee handbook. If you haven't done it in a while, or even if you did it last year, it's going to need an update. And because there's been quite a few changes in the laws that are significant enough where your handbook should be changed. So we not only have the paid sick leave, but this new employee-friendly NLRB, the National Labor Relations Board standard, and that's going to make a lot of changes into your sprinkled throughout your handbook. So we'll talk about that as well. And then there's some new FEHA protections as well for unique to California. So definitely this is the year, if you've been thinking about it, to update or get a new handbook for your company. Let's talk about the leave of absence expansion, which is the paid sick leave. It's almost double the amount that was previously required. So the increase in annual amount is going from 3 days or 24 hours to 5 days or 40 hours. So this is quite a significant jump for you all. That really the big change is just changing it from the 24 hours to the 40 hours. You may use 5 days or 40 hours each year. You can still use the lump sum or the accrual method. Remember, we get a choice in California. We can either do a lump sum where we're front loading everybody the amount, or we do the accrual method. And if you care to know, you can have differences. You can have, for example, your full-time employees following a lump sum front load, and that might be easier for your accounting department to track and for your employees to understand. And then for your part-time employees, because maybe they work very part-time, you can have an accrual method for them. Just distinguish that. And again, this is where your handbook's going to come in handy, because you're going to distinguish that on there. So if you're choosing the accrual method, the cap on the sick leave is increased to 48 hours or 6 days. It's increased from, 48 hours or 6 days to now 80 hours or 10 days. You can still limit the use of that to 5 days, but you do need to increase the cap on that. So let your payroll company know that, it used to be that our cap was 48 on that accrual, and now we need to increase it to 80 hours. And you still, again, define that in your handbook, because a lot of employees get confused. Why am I getting 80 hours if I'm not allowed to use them? So explain that. Have a sentence or two that explains why that is. The accrual rate is still at least, that hasn't changed, 1 hour for every 30 hours worked. This includes overtime hours, so make sure you're setting that up that way if you're doing the accrual method, 1 hour for every 30 worked. If you use an alternative accrual method, you don't want to do the 1 hour for every 30, that's okay, so long as it satisfies the requirement. And the requirement is at least 24 hours of paid sick leave by the 120th calendar day of employment. And then you also have to guarantee at least 40 hours of paid sick leave by the 200th calendar day. This is only if you're doing something separate from the 1 hour for every 30. Make sure you're hitting these markers if you have a different alternative to when they're accruing sick leave. Okay, so if there's questions, please ask them in the Q&A, but we're going to move on now from paid sick leave to the reproductive loss or bereavement. This is going to cover various different reasons, and we'll define what that is. But this is in addition to the bereavement. Remember, we had the bereavement leave from last year. The bereavement leave from last year said you have to have at least 5 days of bereavement unpaid for every employee. So if we didn't do that, make sure we get that done, because that's been in place for a year now. Well, now there's been Senate Bill 848 that now says we have to have specifically a reproductive loss bereavement. And this is for employers with 5 or more employees. You have to now provide 5 days of bereavement for a reproductive loss. A reproductive loss is defined as a failed adoption, a failed surrogacy, a miscarriage, a stillbirth, or an unsuccessful assisted reproduction. So if your employee falls under that definition, this is not going to fall under the normal bereavement leave. It's going to be a different leave. Employees are eligible at 30 days of employment, and you can limit this to 20 days in a 12-month period. So if somebody is going through, for example, an unsuccessful assisted reproduction, it could be that this happens more than once in a 12-month period. You can limit that to 20 days. There are some pretty strict confidentiality provisions here, so ensure you're keeping and maintaining confidentiality as you do all medical situations. The big one with this that is hard for employers to accept is that there isn't any certifying documentation. So different from our bereavement leave from last year, where we can, if we want to, we can request a death certificate, a program from a funeral, something that certifies that they had a loss for bereavement. Well, we can't do that for the reproductive loss. So ensure your policy isn't requesting that your management team is trained on this, because we cannot ask for any certifying documentation. We really have to take them at their word, and we're hoping people, don't take advantage of this, but well, we'll see how that goes. This leave has to be used within 3 months of the event, unless the employee takes another protective leave first. This reproductive bereavement leave is separate and apart from CFRA, the California Family Rights Act, or the FMLA. It does not run together or concurrently. You can take this bereavement after the other leave. Maybe you're having medical issues associated with this and you're on a CFRA, and then now you're taking your reproductive bereavement leave for 5 additional days. That can be okay. The leave days need not to be consecutive. Maybe something's going on this day, and you get 5 days total, but they don't have to be consecutive. This is an unpaid leave, so just as the bereavement leave is, we're okay in offering them to use accrued paid sick leave or paid vacation, but it's not a paid leave for the employer. So make sure we're revising our bereavement leave policy, ensure that we're looking at it and expanding on it, and covering the reproductive bereavement part of it, that it's an additional 5 days separate and apart from the normal bereavement. So what to do in this section as we're rounding up this section, make sure you're updating your paid sick leave policy. And what that means is you're going to update the policy to increase it if you haven't already. Watch out for those municipalities. If you have employees working in a different city, county, you want to make sure that you're following that rule for paid sick leave. So if you have employees entering into San Diego, for example, for a job, and they're spending more than 2 hours in the city, that paid sick leave and minimum wage, by the way, would apply. So ensure that if it's an employee working remote, that you're checking the paid sick leave for that employee where they work. Where they conduct the work is the policy you follow. So you also want to make sure the wage statements are correct, that you're putting in the correct accrual or the correct amount of paid sick leave under the wage statement, and that you're also notifying. Remember, we have that update wage theft notice, that Labor Code 2810.5. That's for hourly employees. It's a mandatory form that we give them at new hire, and anytime there's a change to their wage or their paid sick leave. So you want to update that. It could be in a different format. It doesn't have to be the Labor Code 2810.5 form, but that's usually what we recommend. It's a best practice. It's consistent. You were just giving them the updated wage theft notice. If you're an employer who forgot to do that, this is a great time to now get updated and ensure all your employees have this wage theft notice in their file. Some employers, and also you need that required poster. So this is another year for poster updates, because there's been a change to that paid sick leave, and that's one of the items on those big mandatory posters that you have. Some employers are looking at whether they need to alter their vacation accruals or their paid holidays. Maybe I had a combined PTO plan and now I want to separate them and have a sick leave and a vacation policy separate. So look at that, or maybe it was separate and now we want to combine them, which we don't typically recommend, but it is an option that you can consider. So remember, again, review those local sick leave ordinances. And if you need posters, please check us out at employers.org. We have those options available to you. So some new employee protections here. We're going to move on from this area and talk about cannabis. We're in California. There's now a new protected class under the Fair Employment Housing Act. So remember, the Fair Employment Housing Act has anti-discrimination and harassment provisions, and that they list out the protected classes for California: gender, age, medical condition, race, all those things, religion. Well, now we have cannabis as a protected class in California. And AB 2188 passed last year, but the start or the effective date is January 1, 2024. The way we're looking at cannabis use is the way we look at alcohol in the workplace. Employees are free to use alcohol outside of work Same thing happens with the cannabis use. They're free to use it outside of work when they're not working, but employers need to know that they cannot discriminate or take adverse action against an employee that's a current employee or an applicant if they're using that cannabis off-site and away from work. But it doesn't permit them to come to work impaired or to possess anything while they're at work. So if you see paraphernalia, if you see something, you see them smoking or doing something while in the premises of work, you're more than okay to confront the employee about that. And we'll talk about reasonable suspicion testing and all that. The exceptions to AB 2188 is building and construction trades. So if you're in that industry, when the testing is required by state and federal law, because federal law contracts will say we need to drug test. So if that's the case, you're exempt from 2188. But the rest of us have to deal with this drug screening. We're unable to drug screen for the non-psychoactive components, because that non-psychoactive component that a drug test typically looks for when they're drug testing indicates past use, and cannabis can stay in your system for weeks. And so we can't rely on the current testing that we used to have to be an accurate test for an employee that may be under the influence. So some practical results, what we can do, what are your options? You can choose not to test for cannabis. So call your employer and your drug testing facility, your workers' comp clinic, whoever does your drug testing, and say, you know, that panel of all the drugs we test for, take cannabis out of it if you're able to do that, and make sure you apply that policy consistently. Or if they have a compliant test, and we tend to hear the saliva test is a more compliant test than the urine. If you're able to test using a compliant test that will actually test to see if you're actively high and not something that you used in prior days or weeks, then you're free to use that test. But you're going to have to make a call to your drug screening provider to see if they're up to date with the compliant test. And if they're not, you're going to have to choose to eliminate that cannabis test from the panel of drug tests that you have. So you can continue to do reasonable suspicion. You can continue to do new hire testing. We just cannot test for this drug specifically if it's testing for the non-psychoactive components. So again, a call to your workers' comp clinic or your drug testing screen is what you should probably do. If you have additional questions on this, or if you need a drug screening provider, OcuScreen is our vendor. You can find them on our partners page on employers.org, and they can help guide you to finding a drug clinic. Okay, sort of along the same lines here is Senate Bill 700, which is the cannabis history. It is also unlawful to request information from an applicant regarding their prior cannabis use. I don't think many of us were doing that, but this is playing to the application. If you have an application that asks, have you ever been convicted of a marijuana or a drug, you can't ask that because that's unlawful. We can't request that information from an applicant about their cannabis use. We can't talk about it when we're interviewing them. You know, are you a frequent cannabis smoker recreationally? We can't ask that during an application. The only exception here would be if you say, I'm making a job offer and is contingent upon you passing a drug test and maybe a background check. And then you find out in the background check that they have a criminal history that is regarding cannabis. At that point, you would have to go through the Fair Chance Act and talk to them, the interactive process, sort of, if you will, about the criminal history in order to see if that cannabis conviction is something related to the job or not. That would be the only time you can ask them about it. Otherwise, we're not asking that question. We don't want to know about it. If they volunteer that information to us, we need to disregard that as a reason why we're from the interview process. Okay, moving on rather quickly here, and I'll just pause and see if there's any questions here that I think you're doing a great job, Mary. Thank you of answering them, but let me know or in the chat if I need to address anything more significant.
Yeah, I was just going to pop in really quick,
Sure.
Astrid, a couple of questions on PSL. Just as a reminder for everyone, yes, PSL does apply to part-time and full-time employees, but an employer could have different plans. So for example, if for your full-time employees, if you just want to dump 40 hours into a lump sum bucket for them on January 1st, you can do that. For your part-time employees, they can accrue based on time worked. So there's a couple of different options, but that's a great opportunity. Give the hotline a call if you want to talk about different options, and we can kind of let you know the pros and cons to each. But everyone gets paid sick leave, yes.
Absolutely. Thank you. Yes. And that's a big one, especially for your part-timers. And again, if you have a very part-time employee, do what Mary's suggesting. A lot of employers are doing that, the 1 hour for every 30 option, because they may not get to 80 hours, and you would be compliant. But if you offer a different accrual, then you have to meet the markers, the 24 hours and the 40. So we don't want to use a different accrual for part-time if that's your goal, is to see it, limit the amount of sick leave they accrue, then do the 1 hour for every 30, and then you'll be okay. Good questions. And okay, so just because this is a shorter webinar, we're going to move on to the Senate Bill 700. Again, I think we talked about that, the Fair Chance Act, which is more to come on that one. We will be discussing that as well. And I know there's a lot of drug questions out there, and this is hitting us hard because people are concerned with the type of work that employees are doing out there. I just did a presentation last night, and it was for plumbers that go into people's homes, and they said, well, how can we not test for that? So again, you can still do reasonable suspicion testing. We just can't test for that psychoactive component. We can still test to see if they are currently high, just not if they were high last week. That's the new rule. Okay. So moving on, this is kind of a big one, I think, the National Labor Relations Act, or the NLRA Section 7. A lot of times employers will tune us out because they think this is union talk, but in fact it is not union talk. This NLRA is enforced by the National Labor Relations Board. It includes protections to all employees, private and public. So it's a common misconception that we think this is only protecting union people. But Section 7 grants employees the right to communicate about wages, hours, and terms and conditions of employment. So Section 7 is what allows employees to say, you know, this is a crummy place to work here. Or, hey, John, how much was your raise? Or we don't really like this manager, and we really want to make a petition to see if we can get a meeting with the big boss about it. So Section 7 is allowing employees to be able to gripe about their working conditions, their wages. This is something that not just union, but any employee in any company can bring concerns up. So this is a big one because we can't limit that type of talk. And the way some employers limit that type of talk without realizing is by setting very strict policies. And so we want to make sure that your policies are being checked, that you're looking to see if you're restricting employees from making those complaints. So ensuring that your open door policy is very clear, that you can always come and complain, you can go up the chain, you can skip steps possibly and go straight up. So again, a challenge workplace rule, so a policy, will be presumed unlawful if it has a reasonable tendency to chill employees' exercise of their rights. So that's what they're finding. They're finding that certain policies restrict employees so much that it's chilling, it's freezing their employees' right to complain. So the employer may rebut that presumption by providing the rule advances a legitimate and substantial business interest. So they can say, look, that's not our intention with this rule. This is the reason why. But the burden is on the employer to defend that. So what we're saying is check your policies in your handbook. I know CEA has revised. We've gone through all of our handbook to ensure that even if we do restrict, there's certain policies that talk about professionalism and how to conduct yourself with coworkers. But we'll put a little disclaimer on it and we'll say this in no way interferes with your Section 7 rights. And having that disclaimer really will again just be more protective to the employer to ensure that you're not chilling their exercise of their rights. So consider doing something like that. You can actually look at our edits that we've done on our website at employers.org under handbook. We post our updates on there. And if you look at our updates, you'll see that we've done that throughout the handbook on there. So that's another area that we really want employers to consider. We really want them to spend the time reviewing that. And then some other to-dos, if you have tested employees for cannabis, determine whether you'll continue to test for it. And a lot of employers have stopped testing for cannabis even last year. Or ensure you're using a saliva-based or other compliant test so that you're able to continue testing. We have at CEA on our website a reasonable suspicion drug testing policy. Members can access that. That's a really good tool to keep by your desk side and have your supervisors and managers know about it, because when someone is under the influence, you need to react to that right away. You need to know legally, what can I do? What are the steps? What if they refuse to take the test? What if I had one say they refused to it was back when we were doing the urination test, and he wouldn't go. He spent 5 hours on a chair waiting to go. So what do you do with that if that happens? So update, talk about these things, have a plan in place, have a policy in place of what is it that we're going to do to ensure when the time comes, you know what the company is going to do. And you also have the hotline. So give us a call and we can talk through it. Sometimes things don't happen between 8 and 5 though. So have a plan in place for when we're not available, and you'll know what to do. So update those policies as needed. Again, train those managers on the protections, audit that handbook and the policies so that you're in compliance with the new NLRB standard. Again, that's a big one, because we hadn't had any the NLRB say something like that. And now they're going to be looking for that type of language, restricting employees out there. Any questions before we move on to the wage and hour section, Mary?
Hey, I think we're all caught up. I am going to drop into the chat box a link to our CEA store and our employee handbook. So all these amazing and scary policies that Astrid is talking about, we have them all written and ready for you in a 2024 updated employee handbook. So if you're thinking, oh my gosh, how do I write a reasonable suspicion testing policy? Don't you worry. We've done it for you. So I'll drop a link in there. You can purchase that. It'll get sent right to you. You can put together a customized handbook that'll have all the language that you need.
Thank you. Yes, absolutely. Yeah, utilize that, because it's great to get the advice, but like Mary's saying, when you have to word it, and you want to make sure you get it right. So we've done that work for you. Okay, so moving on, because California never fails in increasing that minimum wage. And that implies a lot of different things. When minimum wage goes up, it impacts our budget in a significant way, both for our hourly employees who now are, maybe you were paying over minimum wage, but now minimum wage is creeping up to what you were paying, which was competitive, but now minimum wage workers are making 16, and in our fast food industry, they're going to be making even more. So you got to compete with that, those employees, and how minimum wage is affecting the industry. So in California, our non-exempt hourly folks are making $16 an hour. That's an increase of 50 cents from last year. And whenever there's an increase to the minimum wage for your hourly employees, there's an increase to your exempt or your salary, because the way you reach exempt status when you have an exempt employee, you have to double the amount of minimum wage for the state, not for the local or local county or city where they may be higher than 16. When you're looking at exempt, you only have to double the state minimum wage. So that was a significant jump from last year. It went from about 64,000 and change to now 66,560. So if you are an employer who forgot to do this, we need to increase those exempt employees to at least 66,560. The other option that you have is transitioning them from exempt to non-exempt to an hourly position, which is sometimes a very difficult thing, I realize, for our exempt employees to have to adjust to. Now they have to have a timesheet. Now they have to take their meal periods by the 5th hour, but that is an option. If you really can't afford to do the increase from the 64,000 to 66,000, then just take the salary they were making and convert it into an hourly rate. And that hourly rate becomes now it hasn't changed, but now they're eligible for overtime, and they do need to track everything. If all that seems overwhelming, we have this employee relation tip for you. It's a bit.ly. If you enter that in, you'll see that we have a fact sheet of tips of how to communicate and how to transition an exempt employee to hourly. The other thing I'll say about exempt employees in California is that it's not just the salary. So if you want to make someone exempt, you have to meet 2 criteria in California. The salary is one, and then the job duties is the other. So you want to make sure that you can't just make someone exempt by paying them that. They have to qualify for the exemption. Employees in California are presumed to be hourly unless they meet the criteria to be exempt. So again, go to our website. You can see what the criteria is. There's about 5 different ways you can be an exempt employee by being a manager, a professional, job duties, certain things that make you qualify. And you have to do that for a significant portion of your day in order to qualify for exempt. That is a very costly mistake to get wrong, because if you have someone misclassified, then you've missed out on paying them meal periods, or you didn't track them. You missed out on overtime potentially, and breaks, all kinds of things. So there's a significant loss to the employer, risk, if you don't get this right. So we want to make sure to remind employers about that. So remember, and I know in the Central Valley where you all are at, this could apply. So check the local ordinances where your employees work. Remember, it's always based on where they're performing work. And look and see whether the minimum wage is different where they are, or possibly paid sick leave. In the Bay Area, we have predictive scheduling and flex time that applies to employees that enter those counties or cities. So remember, it's where they're physically working, even if that's their home residence. And then again, there's a link there if you'd like to follow that for all the minimum wage. We track that. We love tracking that. There's also some industry specific wages, like I mentioned, the fast food, that we'll talk about in a bit. Okay, we're moving on, still in the same vein of wage and hour. The personal vehicle use. We want to remind you that you do need to reimburse costs incurred by the employee on behalf of the business. And that includes mileage. So, we're reimbursing employees when they're going to the post office because they're doing it for us. They're going to go mail that letter, or they're going to go run those I was going to say fax, but that's really dating myself. I don't think even Kinko's has fax machines anymore. Maybe they do. But, if you're telling them to go buy supplies for the office, you're paying them for the time it takes, if they're an hourly employee, to get to the post office, to get to the Staples. And then you're also, don't forget, paying them mileage when they're using their personal vehicle for work. Even if it's a mile or two, we're reimbursing them for that. And that IRS mileage is what's new for 2024. It has increased. It was 65.5 cents, and now it has increased to 67 cents a mile. So the IRS has said that is a reasonable reimbursement amount for mileage for your employees, which is great, because how would we know if what we're paying and reimbursing them is enough, is sufficient? The labor commissioner in California has said we will recognize the IRS mileage rate as a reasonable standard for you to reimburse your employees. It covers things like wear and tear and gas, but you may be an employer who says, I want to pay less. I know that that's what they say, but I think that's too much, and I want to pay 50 cents a mile. Maybe you give them a gas card to cover their gas, and so really it's just the wear and tear that you're providing for them, so you pay less. That would be okay. But if you do that, the burden is on you, the employer, to ensure that that amount you're paying is sufficient. So that's why we at CEA just say use the IRS mileage. That you'll know you're covered, because the labor commissioner has come out to say that. So remember, you have to pay your employees for actual drive time, which is work time, in addition to the mileage reimbursement. If your employees are engaging in travel and working, you can actually pay a different rate for that. It can be as low as minimum wage. So your employee may make $30 an hour on their normal job, but then they have to drive. And so that driving time, which they do maybe twice a week, you're going to pay the minimum wage for that, or even a lower rate. Just can't be lower than minimum wage. You can do that. You can track 2 different rates of pay. But when you're tracking 2 different rates of pay for your hourly employees, you have to remember there's a regular rate that's a blended rate that you then use when paying out sick leave, which is, again, this is it for another wage and hour webinar. But call the hotline if that confused you, or if you're understanding it but need additional information. Make sure that we call in and we can clarify it a little bit more. Along the same vein here is the remote work expense reimbursement. So if you have remote workers, if you have hybrid workers and you really love it because now they're not coming into the office, it's saving you some money, so you're encouraging it or you are requiring it, then you should cover at least basic work from home cost. Things like internet, office equipment, a laptop, a printer, personal mobile phone use, you're going to reimburse them for that, because we have lots of cases in the labor code that says you have to reimburse for employees for those costs. How much do you reimburse them? you have to determine what's a reasonable amount. So it could be a reasonable percentage of the total cost. So maybe I have an unlimited phone plan. It's really not going to cost me anything to send that picture to my boss every day that he needs a picture of the coolers and the temperature on the coolers where I work at, and he needs a copy of that picture every day. It's really not costing me anything. But that case has been heard in courts, and the courts have said you still, even though they are having a limited plan, even though it's not really costing them anything, you must still reimburse them a portion, something reasonable. And so you're going to look at what is it that employees are using the phone for, what is it that they're using the internet for, and pay something reasonable. It could be something like $10, it could be something like $50. You're going to look at someone who's fully remote versus hybrid and pay percentages based on that. And if you're doing a expense reimbursement and asking for receipts, here's my internet bill, please reimburse me a portion of that. No problem, that's an expense reimbursement. You could also go the stipend route. Employers can say, I'm just going to do a work from home stipend. That includes all this stuff, the internet, maybe even utilities, which is another thing that's in the courts right now, utilities. We have employees saying, it's so cold right now, I have to turn my heater on and my gas bill is higher, so you have to pay me now, employer, for my gas bill. Well, that's typically not something we would normally reimburse for, but that is in the courts right now, trying to be decided. Definitely internet is something that has been decided. We need to pay for that, but the utilities not so much. So again, you're reimbursing for those basic work from home. I was talking about the stipend, I believe. So make sure if you're doing a stipend, you're going to just do a flat rate that includes everything. We're taxing that stipend. That's not a reimbursement situation. That is a stipend that it gets taxed for employees. So that is another option that for you to consider. Again, make sure that stipend is reasonable and it's sufficient. Sometimes we put in a policy that says this is the policy for expense reimbursements. Make sure that you get authorization before you make that charge, before you actually incur the cost, because we don't want a situation where they're buying a $500 chair when the budget was $200. So ensure that you write that into your policy and that you're disciplining if they're not following that policy, making them return it and buy a more appropriate chair, that kind of thing. So build a policy that explains all these things, the expectations, and that you're also checking off that computer, laptop, whatever equipment that you've checked out to that employee, that you're having an agreement, that this property agreement was checked out to you. Have them sign off on that. Sometimes employers put a dollar amount so that if it's not returned, you have something documented that reviews what it is that we have checked out to you, and you have something, a leg to stand on when going against the employee after they're terminated. So some to-dos in this section here: check your county and city minimum wage laws where your employees work. And those county and city minimum wages tend to go up in July. So there's definitely some that we already know about that will go up in July. So again, budget, plan for those things. Expect the minimum wage poster updates. So we do have those minimum wage posters and paid sick leave poster updates. So you can order one through our store in the link that Mary sent. We have those posters available. The only one I think we're still waiting on is the Spanish poster, but all the others should be able to ship out now. And then, as I just mentioned, execute a remote worker agreement for expense reimbursements, but also it defines remote work parameters. What are your hours when working from home? What is the expectation that you be available? What is the dress code? Can you show up in pajamas for a Zoom meeting, or should you have a dress code in place when they're at home? And again, that remote worker agreement is going to include that what we've checked out, the equipment, so that again we have something to prove that this was checked out to the employee and can then request it back once they're terminated. Those remote worker agreements, we have a sample one. It's free to our members. So if our members log in under HR forms, you can find that remote worker agreement available to you. Pay compensable time and reimburse employees for those business-related travel beyond their normal commute. Remember, find what that commute time is. It tends to be, commute time will be, you define what the home base is. So if you have those remote workers that are working from home and you've asked them to come into the office for training and their home base is home, you're now paying them to go into the office. If they're an hourly employee, you're paying them for that commute time and you're paying them for mileage. If they're exempt employee, obviously there's no You don't have to pay for the rate because you're paying them an hourly a salary, but you do need to reimburse your exempt employees for mileage as well. Mileage is for everybody if they're conducting work with their personal vehicle. And then budget for those minimum wage and salary increases, as we know, they're coming up in July, and then for the state annually, it seems to be. Okay. Should I pause there, Mary? Anything outstanding before we move on to safety?
No, we were getting a couple of questions on the reimbursement, which I know is always a little tricky. If somebody is voluntarily working from home, should you still reimburse them? I think, Astrid, you would agree with me on this, where we say you never get in trouble for overpaying an employee.
Absolutely.
So an employee is never going to say, no, 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 well, let me give you some money back.
Right.
That's not going to happen. So when it comes to if somebody is voluntarily working from home, chances are, yes, you should reimburse them as well. We don't have super clear guidance, but it seems like yes. And as Astrid mentioned, there's a couple things in the courts right now. You're probably going to have to end up paying a little more when it's all said and done. We will see. But we do advise take the more conservative approach. And when in doubt, pay it out. It's your safer bet.
Yes, absolutely. And like Mary said, it is in the courts. It should be decided soon, but we're in California, people. This is an employee-friendly state. We kind of know how it's going to go. So probably be conservative. And a lot of times the courts will decide this is retroactive. And so you're probably going to end up paying it anyway, right, Mary?
Exactly. That's the fear. Hopefully not. But again, yeah, we'll see. Stay tuned. But
Yeah,
if you question it, chances are it's probably going to need to be paid out.
yeah. The voluntary one is the one that gets people a lot because, hey, and with expenses, we can answer to, hey, we have a printer here. So when you need to print or when you need paper, come into the office and get a ream of paper or come into the office and print from here. But if it's an optional, we're allowing you to work from home, and those are the gray areas that haven't been decided. But again, it's seeming like we know how it's going to go, but we don't know yet. So err on the side of caution, as Mary is saying, is best practice. Okay, so let's transition over to safety. We have Senate Bill 553, which is a big one for employers, the Workplace Violence Prevention Plan, which I don't know how we're going to do that acronym. We do CFRA, we do FEMLA, but I don't know about this one, Mary. WPIPA. I'm not sure how we're going to do that one. And it's a mouthful to say Workplace Violence Prevention Plan as well. But this is something that we all as employers need to implement and maintain. It's a written plan that has to be in effect as of July 1st, 2024. So we have some time, but as we know, time flies. And so we need to start prepping for this because although we don't have a ton of guidance, we do have some information. It's going to include a training requirement for employees that is when it's established. So in July, we have to train all our employees on this workplace violence prevention plan. And then there's a requirement to train them annually. So at least with our harassment prevention training, we need to train them every 2 years. With this one, it's going to be annually, every year. This came out of the Bay Area in Oakland, I believe it was, where they had that shooting at work it was the public transit, I believe, and the Cal OSHA was working on something, and they've been working on something for quite a few years, like 9 years or something, on developing something like this. But when that shooting happened, that senator in that area said, we need something now. And so that's kind of how Senate Bill 553 came to be. The exceptions to this is if you're 100% remote. So you do not come into the office, you are 100% teleworking employees, you're exempt from this law. You're also exempt if you have fewer than 10 employees at any given time and do not access the public. So you have less than 10, you're a small employer, and you have a compliant IIPP, which is that injury illness prevention plan, which sometimes is not a written plan for small employers. But in this case, if you have something like that and you're a very small employer, then you'd be exempt from this rule as well. Always still a good idea to have it, but it can be something you're exempt from. Healthcare facilities, you're covered under a different standard already. You've had that. Same with Department of Corrections and Rehab and law enforcement. They have a much stricter workplace violence prevention plan and guidance that they have to meet. So this does not apply to them. So what is in this workplace violence plan. See, I'm already having a hard time saying it. It can be incorporated into your IIPP. Remember that injury, illness, prevention plan is a requirement for employees with 10 or more. A written plan is required. So you can include this and incorporate it as part of it. It's not going to go in your handbook. It's going to be part of that IIPP, or you can have it as a standalone document. So your IIPP goes in one binder, your workplace violence prevention plan goes in the other. You do need to have an inspection when the plan is established, meaning you yourself, employer, are going to inspect yourself on things like doing an audit of your building. Where are exit routes? Is the lighting in our parking lot sufficient? Do we have our exit doors not blocked? So this inspection of your building, of your plan, has to happen when it's first established. And then after there's an incident. If you happen to have an incident or a hazard, then you'll have to do an inspection once again, and then periodically as well. You have to record any kind of violent incident. We'll talk about some examples of what that means, what is recordable in a violent incident log following an investigation. Similar to your Cal OSHA 300 log, where you log your workers' comp claims, you're going to have to log any violent incident log. And those records of identification, evaluation, any correction maintained has to be maintained for at least 5 years. Your training records, so your roster of who you've trained and when you train them, those have to be kept annually for just 1 year. This Senate bill has required Cal OSHA to make some standards for this they have some time, by December 31st, 2025, and then to adopt them a year later, because that's usually the timeline they have to follow. That doesn't mean that this isn't going to be enforced. Cal OSHA has been funded to be the enforcement body for the Workplace Violence Prevention Plan. So even though Cal OSHA doesn't have the standards, the Senate bill does. So the Senate bill has standards we all have to follow and maintain and can be fined for. So you want to make sure you start preparing for this. And I lied and I said that there was a slide for this, but incident logs, so what you're going to possible scenarios of where you would record on your incident violent prevention plan. The log would include things like employees fighting on the workplace. Maybe a client threatened your employee. So threat, it doesn't even have to be just a physical fight. It could be a threat of violence that gets recorded. Things like sexual harassment claims, because of sexual harassment, either touching or comments made of a sexual nature. If you investigate and it's substantiated, that goes into your log. Things like an animal attack. If you have employees outdoors and they're going out there and they get attacked by an animal, that gets placed on there. And there's a few others that are kind of more general or varied, and we're hoping Cal OSHA will clarify that a little bit. But those are some things that would apply to the employer, of things that you need to log. So who's responsible for implementing your plan? This is the stuff that you have to get ready for and maintain. So make sure that we're looking into that. We're assigning these job duties out to employees at your staff so that you get ready for that, and plan to deliver this training by July 1st and then annually thereafter. Prepare for inspection, your own inspection, and the record retention requirements. This is also something that's going to be mandatory. Okay, let's go on to some industry specific, just a few more things here, and we may have some time for questions, Mary. But AB 1228 is the fast food chains. So I think I saw some questions on this. So this is an agreement. AB 1228 was passed because the FAST Act was repealed. As you may recall, last year we had the FAST Act, but it was put on hold rather quickly because it was asking for $22 an hour for our fast food workers by last year, 2023. So it was put on hold, and then it was revived again, and it was negotiated, and now we have AB 1228. So these are the new terms. Is our fast food workers are making $20 an hour minimum wage, and this will go into effect April 1st for covered employers. So what this means is, again, we have our fast food workers, and it has to meet the definition of a big chain. So we're talking, people who have 60 or more nationally restaurants. So your big ones, your Starbucks, your McDonald's, they have to pay this. Now, does this mean that the exempt employees in this industry also have to then be double the minimum wage of $20, which puts them at about $83,000 a year annually. Maybe we don't have those answers yet. Likely they may have to follow the minimum wage, like the rest of us are following the state's minimum wage to look at what exempt employees make. They may be looking at this minimum wage rather than 16 an hour. But those questions haven't been answered by AB 1228 yet, so there's going to be some clarity there on who does this apply to specifically and how the minimum wage, how do minimum wage affect salaried employees. The other thing this has done, it's created this fast food council under the Department of Industrial Relations, and this has been created to recommend working conditions in this industry of fast food and set the minimum wage each year until 2029, which is quite a while, right? And so this is a little bit concerning to employers when we look at a fast food council that acts sort of like a union, because they're setting working conditions, setting minimum wage. This has never really been done in industry. So this is something new to the fast food area chains. And, again, dangerous territory when there's one industry. Could it happen in other industries? So Senate Bill 476, different than the Fast Food Act, but the food handlers is something that is also something that's new to 2024. It's going to require food handlers in restaurants to obtain certification within 30 days of hire. California employers now are responsible for the cost associated. It used to be that we could ask you to go get a food handlers if you want to come work for us, and we require that, but we don't have to pay for it because you could quit tomorrow and take it to the next restaurant. Well, now we do. Now we're responsible for all costs associated, which includes the cost of the training, the test itself, the drive it takes you to get to where the test is going to be, the mileage it takes for you to go take that test. So it's going to include all that compensable time. You have to relieve them from their duties to go take the test if you want them to take the test and pass. And employers cannot condition employment on the applicant or the employee if they don't have one. So you can't say as a condition of employment you have to have one already. You'd have to consider every applicant, hire them, and then be willing to go through the process of covering their costs. So update any policies you may have if you're in this industry. Again, another thing, because this is a new trend, this is not something that is for all industries or for all certifications that employees have, but it is something that we're seeing in this particular section in this industry. So we're hoping it doesn't continue on. So the Senate Bill 525, we were going to take this out because it's on hold currently, and this is new from our governor. It's been placed on hold, but it's creating 5 different minimum wage schedules for the healthcare employee industry, and it's not going to affect all healthcare. It's got to be the covered healthcare employees. So it doesn't apply to dental offices, but it can apply to maybe some neighborhood clinics. So you'll have to see whether you meet the definition of healthcare minimum wage under Senate Bill 525. It's going to be based on several factors, but it is increasing minimum wage range for this area from 18 to 23 by June 1st, with set future increases thereafter. But like we said, as of a few weeks ago, it's been placed on hold. We don't know if it's going to pass. It may not go in effect in June 1st. It's definitely on hold right now. So consult with legal counsel. Stay tuned for more information on Senate Bill 525. Follow our blog. We may have more information on this as it comes up. The last one I'll go through is COVID. We don't have that slide, but since we have some time, there's been update to our COVID prevention. This is our first labor law update where we don't include a slide on COVID. As you all know, we've been doing that since 2020, but there is some few mentions on COVID because of the updates. So we still have a COVID prevention plan that is required by Cal OSHA. That is still a requirement. We are still required to tell our close contacts that there's been an exposure, that you have been exposed to someone that's tested positive. But the employee that tests positive, as of last Wednesday, the California Department of Health has said that employees that test positive and show no symptoms can now return to work. They do not have to quarantine so long as they're not showing any symptoms, and they wear a mask for 10 days. And then employees who do test positive and do have symptoms, so long as their symptoms are improving and they have no fever for 24 hours, so they do need to stay out for 24 hours, then they can return if their symptoms have improved and they have no fever for more than 24 hours, they can actually return to the workplace under the same conditions, wearing a mask for 10 days. But employer, you can have a more strict policy if that makes you nervous. If you feel like, no, we need to have a more strict policy, you can do that. But that is the new guidance from the California Department of Health, which Cal OSHA has said they will adopt if those standards are changed by the CDPH, they will adopt them as well. So that is the new standard. You can find it on Cal OSHA's website as well. The new thing for 2024 is you no longer have to tell your workers' comp carrier that you have a positive test. So that's good news. And you no longer have to do that big posting that you would have to put by the time clock, or that mass email you'd have to tell every single person in the company that someone in the building tested positive. That is no longer a requirement. But you remember, you still do need to tell that close contact group that someone tested positive. So no more paid COVID sick leave for that, but we do have that increased California paid sick leave as well. Any questions out there before we close this out, Mary?
Yes. Hey, everybody. A couple of questions just came in. I thought I would just address them here. So are there going to be any IIPP or WVPP or whatever we're going to call that, Workplace Violence Prevention Plan templates available? So yes, there is an IIP template that's available on the Cal OSHA website. You can check that out. That normally works perfectly well for low risk industries. If you are a high risk industry, probably best practice to partner with a safety specialist who can help you out with that. We expect there are going to be some templates for the WVPP. And then we had another question, will there be training? Well, we would love that, but as Astrid mentioned, those standards don't even have to be finalized until 2026. So I can't imagine that they are going to be coming up with training before those standards are finalized. So we'll see. So what happens a lot of times is they will put these laws into effect and they don't necessarily think it through all the way about how that's going to be implemented and how regular businesses are going to do this. So as Astrid mentioned, stay tuned, follow our blog, make sure you're signed up for our newsletters. We will keep people up to date. Again, that doesn't even go into effect until July. So we have a little bit of time for that, but just stay tuned for that. We do expect some sort of template or resource, but we just don't have anything. And if you go Google that right now, you will get some, but they're all for the healthcare industry that are under, or it could be corrections that are under their own standards. So those are a little different. And then we had two other questions. Does SB 476 apply to healthcare organizations, the food handler card? I don't know the answer to that one, Astrid. I know healthcare has a lot of their own guidelines. I haven't heard that they're excluded, but you could give us a call on the hotline and we could see if we could check into that. I'm assuming they have to have that. But
I assume so. If it's a requirement for you to have that, then yes, I would imagine it would apply.
yeah, I haven't heard healthcare is excluded. And then someone was asking for the COVID slides. So we actually don't have a lot of COVID slides. Astrid was just kind of telling you the rundown. Where you can check though is the CDPH. That's the California Department of Public Health. Of course, if you're a CEA member, we've got a lot of resources for members. We've got the COVID exposure toolkit and all that kind of good stuff. But if you're just looking for some general guidelines, check out CDPH. And that is the state website that talks about all these incredibly loosened guidelines that really just did happen last week or the 9th, a week or two ago.
Yeah.
Yeah, it's one of those things that, and there's
2 weeks ago today, actually. Yeah.
They just happen and they kind of don't always
didn't make much noise about it.
Yeah.
And Cal OSHA, as of yesterday, because I just checked actually 2 days ago, finally updated their website. So Cal OSHA has now, if you look at their Q&A, they've updated it now.
Perfect.
As well.
And I think we're all caught up on slides, so I'll turn it back over to you. Thanks, everyone.
Yes, thanks everyone. Great questions. Thank you. And these are the kinds of questions we get into the hotline, so please don't hesitate to give us a call. If you're here for continuing education, we have your HRCI codes 651-638. If you're here for SHRM, it's 24-FETDD. And again, as we've been mentioning, if you need a little additional support, we have our membership that we offer as well. So take the time to look at employers.org and see if this is something that you makes sense to your business and you'd like to partner with us a little bit more than the hotline, then this is available to you as well. Anna, I'll throw it back to you.
Yes, thank you, Astrid. Thank you, Mary, for addressing, I'm pretty sure that was quite a few questions. So thank you all for joining us live. I did drop the HRCI and the SHRM codes in the chat as well, if it's easier for you to copy and paste. And then as she mentioned, you'll see a slide on your screen right now with the QR code. I also dropped that link in the chat. If you can just take the 2 minutes, it's 5 questions, but that feedback really helps us to continue to develop these trainings like this. And we share them with our partners over at Central Valley Hotline. And thank you again to Irene and the whole team over at the Central Valley Regional HR Hotline. Make sure you utilize that resource, and we look forward to seeing you all on the next training. Thank you again so much.